All right, so I think it's time to discuss a federal law called Protecting Tenants at Foreclosure Act. And the reason I think it's necessary is this month alone, the month of May, I've received 2 phone calls from tenants that their rental property was foreclosed on, and we are starting to see an uptick in foreclosed properties. So I think it's prudent at this point to discuss this law just in case you find yourself living in a home that's been foreclosed on. So let's get to today's video. Now, to understand the protections that this law offers tenants, you have to understand the history of it. This law was originally passed in 2009 during the mortgage crisis, when we had thousands and thousands of homes being foreclosed on and thousands of tenants not knowing what their status is. They didn't know what their rights were. We had lenders and investors who were buying these properties at foreclosures, not knowing what their rights and obligations were. It was a mess. So Congress stepped in, they passed this law. It was sunsetting in 2018, and Congress and President Trump made it permanent. This is now a permanent federal law that all landlords and property managers and tenants have to know. They have to know just in case this happens. So what does federal law do, or how did this federal law change this process? First of all, tenants, if you're living in a rental property that's being foreclosed on, you do not have to move out of that rental property during the foreclosure process, nor for a period after the foreclosure sale has happened. But there is strings attached to this. There are certain things you as a tenant must do to get these protections. And the first thing is you have to continue to pay your rent. Now, during the foreclosure process and after, who you pay your rent to may change, but regardless of the change, you have to continue paying your rent as previously agreed to with that original landlord. So during that foreclosure process, one of the things that we've seen during the mortgage crisis, and it actually made the mortgage crisis much, much worse, is the tenant would find out that the landlord was not paying their rent. So then they're like, screw it. If the landlord wasn't making their mortgage payment. So if the landlord isn't making their mortgage payment, then I'm not going to make the rent payment, which made the entire crisis even worse. So under this law, if you're going to get the protection that's afforded to you under this law, you have to continue to make your rent payment. Now, who do you make the rent payment to? Well, you have to continue to make the rent payment to the landlord until such time that you've been notified that you're going to pay someone else. And how does that happen? Well, there are 2 scenarios in which you may end up having to pay someone other than the landlord. The landlord's still going to own the property, and you're still going to make your maintenance request to the landlord, but your rent payments are going to go to either the lender or the lender's property management company that they've hired. And it happens under 2 doctrines. One is called the assignment of rents. If a landlord is in default on their monthly mortgage payment, then they can invoke the assignment of rents. They're going to notify the tenant, and then the tenant is going to start making their monthly rent payments directly to the lender. Under mortgagee in possession, this is where the lender, mortgagee simply means lender, the lender takes the physical control of the property. They don't own it yet because the foreclosure sale hasn't happened, but they've taken physical control of it. And then they typically hire a local property management company to, for the day-to-day operations. And that management company or the lender is going to notify the tenant that they need to start making their monthly rent payments to that property management company. The point is, tenants, for you to get the benefits and the protections under this law, you have to continue to make your rent payment to whomever has been designated to receive that rent payment, whether it's the landlord, whether it's the lender, or the lender's authorized property manager. Key point. That's the string that's attached to this law if you're going to get those protections as a tenant. Today's video is sponsored by Performance Property Management. Hey, landlords, if you're sick and tired of the grind, you're just sick and tired of tenants and the tenant issues and maintenance and showing properties, etc., you're just done, but you want to maintain a portfolio of investment properties, turn it over to a property management company, and there's not a company better than Performance Property Management, commonly referred to as PPM. I don't give my recommendations here lightly, so call PPM, ask for John. He's going to treat you like gold, I guarantee it. So give them a call. I'll leave their contact information right down here. All right, let's get back to our video. Number 3, now after the foreclosure sale has happened, now remember, when the foreclosure sale happens, ownership transfers to either someone who purchased it at the foreclosure sale. In Nebraska, we actually call it a trustee sale. Or the lender was the highest bidder, and the lender is now going to own the property, and they're going to turn around and sell it. So after the foreclosure happens, you got to continue to make your rent payment. They've put some protections for the tenant in there and some clarifications for the landlord or the new owner regarding a partial month rent payment. And I have an example on your screen of what I'm talking about here. So let's say May 1st, the tenant makes their May rent payment. They made it to the original landlord. The foreclosure sale happened on the 15th. Now we have a new owner. During the mortgage crisis, no one knew whether or not the landlord could ask or require the tenant to make that rent payment from May 15th through the 31st of May. And many of the people buying these properties were investors, and they were requiring the tenants to pay. Now, if you're the tenant, you've paid double rent, because what happens at foreclosure is the landlord never transfers partial rent payment, that second half of May's rent payment, to the new owner or the lender. That never happens. So under this law, tenants, if you've made your rent payment on May 1st, then your next rent payment is June 1st, regardless of who owns it. So the new owner cannot go to the tenant and require them to pay from May 15th, the foreclosure date, through May 31st. They cannot go after them, for judgments or turn it over to collections, because they are protected under this law, assuming they made their rent payment on May 1st. However, the new owner is entitled to the rent payment on June 1st. So the tenants would make the rent payment to the new owner on June 1st. And the amount of that rent payment is whatever was stipulated in their original lease agreement or rental agreement. Whether it was month to month or fixed, it doesn't matter. If they were paying $1,000 a month to that landlord, the new owner must accept that $1,000 a month. All right. The key here is for you tenants is you have to continue to make your rent payments to get this protection. It requires new owners, whether that new owner is an individual that purchased it at the trustee sale or the foreclosure sale, or the bank who bought it at that foreclosure sale. It requires them to honor and adhere to the terms of the original rental agreement that tenant had with the landlord. All right. So if an investor, someone who's not going to be an occupant that purchased the home, then if the tenant's 6 months into a 1-year lease, then that tenant is allowed to fulfill the terms of that lease agreement. In the meantime, the new owner cannot raise the rent, they can't evict them, etc. However, there is an exception. If the new owner that purchased it at the foreclosure sale, or in the case where the lender purchased it and then they sold it to a new owner, if that new owner is going to live in that property themselves, so it's going to be owner-occupant, then they are allowed to give the tenant a 90-day notice to vacate. And that is true even if that tenant is 6 months into a 1-year lease. If the new owner is going to be an owner-occupant, then they have a right to give a 90-day notice, and then that tenant would have to vacate. It's a legal way for the owner to break that lease. They have to give them 90 days. If the tenant does not move out in 90 days, then the new owner is going to have to evict him under whatever, the state law, under the Nebraska Landlord Tenant Act requirements. Okay. The key distinction under number 4 is whether or not the new owner is going to be owner occupied or not. Now, if the new owner lies, if the new owner says that, yes, I'm going to be an owner occupant, but they're really not, then the tenant can sue, and this goes into federal court because this is a federal law, And the penalties for that and the punitive damages can be quite excessive. So make sure that new owners, landlords, investors, whatever, make sure you're telling the truth. Last but not least, state and local governments can make the requirement instead of 90 days, as we see under this law, they can extend it as long as they want. So there are some jurisdictions that have made this 6 months instead of 90 days. So in this case, in that jurisdiction, the new owner would have to comply with the 6-month rule, not the 90-day. All right, that's important to remember. Whether it's this law, whether it's landlord-tenant law, whether it's lead-based paint, no matter what, the best thing that you can do as a landlord or manager is stay informed. The best way to do that is to join our weekly email list. I got a link down below, or you can check out this video right here, and they'll tell you how to stay in touch with us. That's all I got. I'll see you all in the next video.